You know, the moment a company has to admit it's really on the edge, it's not just facing like business failure. Suddenly, they're staring down this incredibly complex legal maze. Everything just shifts.
It's a total crisis point. The clock starts ticking, and all these formal legal systems, they just kick right in.
And these aren't vague guidelines, are they? We're talking super detailed rules.
Oh, incredibly detailed. Rules that dictate, everything. Who gets notified and when, how every single asset is handled, the timeline for huge decisions like selling off big parts of the business or getting a rescue plan approved.
And at the same time, inside the company, there's this massive strategic battle just to survive, right?
Absolutely. You've got leadership fighting tooth and nail to keep the doors open, making these impossible choices, trying to keep the team together, all under just immense financial pressure and legal scrutiny.
So we've got two angles to look at this from today. We have these excerpts from the Federal Rules of Bankruptcy Procedure. That's the legal playbook, basically.
The nitty-gritty legal code that structures the whole thing.
And then we have this Forbes piece that really digs into the business side, the leadership challenge, the strategy you need for a turnaround when you're in that kind of crisis.
Yeah, the human and strategic element within that legal framework.
Exactly. So for anyone watching a company in distress, maybe involved professionally, or even exploring things like distressed asset investing, understanding both parts seems crucial.
It really is. You need to see the rules of the game and how the game is played on the ground.
So that's our deep dive today, trying to unpack that interplay between the legal structure and the business strategy when companies hit the wall in the U.S.
Let's get into it.
Okay, so before a company even gets into this system, these rules, where do they even come from? Who writes this incredibly detailed rule book for U.S. bankruptcy?
Right. Good question. It's actually a pretty structured and quite thoughtful process. It's designed for stability and to really pull in expertise. These rules, the federal rules of bankruptcy procedure, people usually just call them the bankruptcy rules. They aren't just dreamt up somewhere.
They don't just appear.
No. They're developed and officially prescribed by the Judicial Conference of the United States. You can think of that as the main policymaking body for the whole federal court system.
The Judicial Conference.
Yeah.
Okay, so it's not Congress writing these specific court rules.
Yeah.
Or just the Supreme Court deciding everything. It's this body focused purely on court operations.
Exactly. It's focused on the judiciary. And what the Judicial Conference does is it appoints specialized committees. So there's a committee specifically for bankruptcy rules.
Wow.
And that committee is tasked with recommending new rules or changes to existing ones. And who's on it? It's a mix. You've got judges who actually use these rules every single day, both trial judges and appellate judges.
Makes sense.
You've got experienced lawyers, the ones actually navigating these cases for clients, and often academics, too. It's really designed to bring together practical experience and, deeper legal thinking.
That mix seems vital. You need the people living it day to day involved in writing the rules. Is the process itself, open? Can people see what changes are being considered?
Transparency is definitely a big part of it. There are public notice requirements baked in. Before one of these rules committees even meets to talk about potential changes, they have to give sufficient notice.
So anyone interested could, in theory, track what they're discussing.
Yeah, exactly. Lawyers, academics, maybe industry groups affected by the rules, they have the chance to attend and observe the discussions. It's not supposed to be a secret process.
So you can kind of see the sausage being made then.
Pretty much. And it goes further than just the meetings. When a committee or the whole judicial conference recommends a proposed change, a new rule, or an amendment, they have to publish the proposed rule itself.
Okay.
And crucially, they include an explanatory note. This tells you the purpose of the change, what they intend it to do, plus a detailed written report of their work. And this report has to include any minority views or separate opinions from committee members.
Wow, so you can actually see if there was disagreement within the committee about a rule. That level of detail feels like it's really about building a clear record.
It is. It creates a kind of legislative history for the rule change. It explains the thinking, shows that different perspectives were considered. It's very deliberate. Now, one small caveat, the law does say that, if they mess up slightly on one of these procedural steps, like the notice wasn't perfect, it doesn't automatically kill the rule if it gets adopted later.
Okay. The procedures are important, but the final rule is the focus.
Right. The procedures guide the process, but a minor procedural slip-up doesn't necessarily invalidate the substance.
Got it. So that structured process creates this detailed rule book. Once those rules are set, what's the very first, practical step? A company decides, okay, we need to do this. How do they actually start a bankruptcy case?
Well, the fundamental step at its core is actually quite simple. You kick off a case by filing a petition with the clerk of the bankruptcy court.
Just filing that document.
That's the official trigger. It seems basic, but it's what puts the whole legal system in motion. It's the formal signal to the world, and especially to your creditors, that you're seeking protection under the bankruptcy code.
And that filing isn't just paperwork. It has immediate legal consequences, doesn't it?
Oh, absolutely. Huge consequences. The second that petition is filed, it triggers the automatic stay.
The stay, right? The big pause button.
Exactly. It's an immediate court-ordered stop sign. It generally prohibits creditors from taking almost any action to collect debts or enforce liens against the debtor or their property. It buys critical breathing room.
And who gets notified right away?
The rules require the court clerk to promptly send a copy of that petition straight to the United States trustee or the UST.
The UST, that's part of the Justice Department, right? An oversight role.
Correct. They play a really important watchdog role in bankruptcy cases, making sure everyone follows the law, overseeing trustees, things like that. They need to be looped in from the very beginning.
Now, we usually think of bankruptcy as voluntary, the company chooses to file.
Mm-hmm.
But can creditors actually push a company into bankruptcy?
Yes, definitely. That's a key part of the system, too. It's called an involuntary petition. Under certain conditions laid out in the code, creditors can band together and file a petition against a debtor to force them into bankruptcy.
Oh, okay.
The rules lay out the procedure for how that works. There are even specific rules for involuntary cases against partnerships because their legal structure is a bit different. So yeah, it's not always the debtor raising their hand first. Sometimes they get pushed.
What about situations with individuals, like if someone is incapacitated or too young to file for themselves?
The rules cover that contingency, too. There are specific procedures for voluntary petitions filed for an infant or someone legally incompetent. It ensures their interests are looked after, often involving the court appointing a guardian or representative.
In international situations,
Yeah.
what if a company has operations or assets, scattered across different countries? How do U.S. rules handle that?
That gets into Chapter 15 of the Bankruptcy Code. That chapter specifically deals with cross-border insolvency. The rules spell out what's needed in a petition when someone, usually a foreign representative, asks a U.S. court to recognize a bankruptcy or insolvency proceeding that's already happening in another country.
So Chapter 15 is about coordinating with foreign courts. Sounds complex.
It can be, yeah, because you're bridging different legal systems. The petition needs key information like designating the country where the debtor's center of main interests, or COMI, is located. That's a core concept to figure out the primary jurisdiction.
Okay.
And they also have to identify any other foreign proceedings involving the debtor that they know about. The foreign representative filing the Chapter 15 petition has to provide a fair bit of info.
Like what?
Things like details on the debtor's corporate ownership structure, who's authorized to administer the foreign case, lists of known creditors. It's all designed to give the U.S. court a clear picture to help it cooperate effectively.
Okay, so filing the petition, whether voluntary, involuntary, or Chapter 15 is step one. It gets the ball rolling. But that feels like just opening the door.
Yeah.
What happens immediately after? This is where all the information starts pouring in, isn't it? The real data dump.
Oh, yeah. This is where it gets really intense, information-wise. You hit the nail on the head. The rules demand a massive amount of disclosure right up front, or very shortly after the case begins. It's all about transparency.
Forcing the debtor to lay all their financial cards on the table.
Exactly. We're talking incredibly detailed lists of every single creditor. Who they are, how much they're owed, why they're owed money, whether the debt is disputed. Then comprehensive schedules of assets, everything the debtor owns. Real estate, equipment, inventory, bank accounts, intellectual property, even furniture, with estimated values.
Wow.
And on the flip side, equally detailed schedules of liabilities, every single debt owed. Plus, these extensive documents called Statements of Financial Affairs.
What are those?
Think of them like a financial history questionnaire on steroids. They ask about income sources for the past few years, major payments made, asset transfers, lawsuits, insider dealings, property repossessed. a huge amount of historical financial data.
That sounds like a monumental undertaking,
Yeah.
especially for a company that's already in crisis mode.
It absolutely is. And there are tight deadlines. How quickly depends a bit on how the case started, voluntary or involuntary, and which chapter it's under, like chapter 7 or 11. But for example, in an involuntary case, some of this might be due just 14 days after the court officially enters the order for relief.
The order for relief. That's the court basically saying, okay, this case is officially proceeding.
Right. It confirms the bankruptcy is underway and the automatic stay is fully in effect. In voluntary cases, a lot of this information is expected pretty much right away, often filed with the initial petition or within a couple of weeks.
And for individuals filing, there are extra requirements too, like the means test stuff.
Correct. The rules layer on specific documents depending on the chapter. An individual filing Chapter 7 has to submit calculations showing their income and expenses to pass the means test.
Which determines if they can repay some debt.
Essentially, yes. It checks if their income is low enough relative to allowable expenses that they genuinely can't afford to make payments under a Chapter 13 repayment plan. If they have too much disposable income, their Chapter 7 case might get dismissed, or they might have to convert to Chapter 13.
And Chapter 11 or 13 filers need income statements too.
Yes, individuals in Chapter 11 or anyone in Chapter 13 needs to file statements of current monthly income. These aren't just bureaucratic hoops. They directly impact eligibility and how much they might have to repay creditors.
I remember hearing individuals also need credit counseling before they can even file.
Generally, yes. That's another requirement baked into the code and rules. Most individuals have to get a certificate from an approved credit counseling agency showing they received counseling within 180 days before filing.
To make sure they understand the options.
That's the idea. And later in the case, they usually have to complete a financial management course, too. There are some narrow exceptions, like if it was impossible to get counseling, but it's a standard prerequisite. Plus, individuals have to file a verified statement with their full Social Security number, although it's kept private.
All this incredibly detailed financial information. It has to be accurate, right? There are penalties for lying.
Oh, absolutely. The rules demand that the petition and all these supporting lists, schedules, and statements be verified under penalty of perjury.
You're swearing it's true.
You are swearing under oath that the information is true and correct to the best of your knowledge. It's a serious legal requirement. Lying can lead to denial of discharge, dismissal of the case, or even criminal charges. Now, mistakes happen, circumstances change, so the rules do allow debtors to amend their voluntary petitions and schedules later on.
Okay, so there's some flexibility for honest errors.
Yes, but the core requirement is accuracy and truthfulness from the start.
So you file the petition, dump all this financial data. What if someone disagrees? Like the debtor in an involuntary case says, no way, I shouldn't be here, or some other party objects.
Right, that definitely happens. That takes us into the early potential fights contesting the petition itself. The rules specify who actually has the right, the standing, to fight an involuntary petition. Usually it's the debtor themselves.
Makes sense.
And in a partnership case, if creditors filed against the partnership, a general partner who didn't join in filing the involuntary petition can also object.
How do they actually fight it? Is it like a normal lawsuit defense?
Pretty much, yes. The rules say that defenses and objections to an involuntary petition generally follow the procedures you'd see in federal civil lawsuits, specifically referencing Rule 12 of the Federal Rules of Civil Procedure.
So motions to dismiss, filing an answer?
Exactly. You can file motions arguing the petition is legally flawed, or file a formal answer laying out why the requirements for an involuntary case haven't been met. And there are deadlines typically. You have 21 days after being served with the petition to respond.
What about those international Chapter 15 cases? Can someone fight the recognition of a foreign bankruptcy?
Yes, the rules provide specific procedures for objecting to a Chapter 15 petition seeking recognition too. It outlines who can object and the timelines, which often run parallel to the involuntary case timelines. If an involuntary petition is contested and doesn't get dismissed, the rules say it generally proceeds like a trial before the bankruptcy judge.
Okay, so there's a clear path to challenge the case itself. What about location? What if related companies file in different states? Can those cases be managed together?
Yes. The rules tackle venue, the proper geographic location for the case, and how to handle related cases filed in different places. If a case is filed in the wrong district, the court can transfer it to the right one or sometimes dismiss it.
And if you have, say, a parent company in Delaware and a subsidiary in Texas?
Good example. There's a really important rule for that. It says the court where the first petition involving related debtors was filed, can actually decide the proper district or districts for all the related cases to proceed. They consider what's fair and convenient for everyone involved.
To avoid having pieces of the same puzzle scattered everywhere.
Exactly. It prevents fragmentation and allows for a more coordinated handling of related bankruptcies.
And if related cases are filed in the same district, can they be formally linked?
Absolutely. The rules allow the court to order consolidation or, much more commonly, joint administration. If you have multiple cases in the same court involving the same debtor, like someone filing Chapter 7 and then Chapter 13, or closely related entities, parent subsidiaries, a partnership and its partners, the court can manage them together for efficiency.
Joint administration. That means they share paperwork but are still legally separate.
Generally, yes. Under joint administration, they might share a case docket, have joint hearings, send out combined notices. It saves time and money. But the assets and liabilities of each debtor usually remain legally distinct unless the court orders something more drastic called substantive consolidation, which is rare and requires a high showing. The rules even let the first court pause activity in later related cases while figuring out if joint administration makes sense.
Okay, so these early rules really seem designed to get the case set up correctly. Start it, get the info, handle initial fights, and organize related filings logically.
That's a great way to put it. If you think about the big picture, these initial rules are the foundation. They build the legal structure for everything else. They define who's involved, the debtor, creditors, trustee, court, the UST. They mandate that critical first flow of information. And they set up the procedures for resolving basic questions like, should this case even be here? Or where should it be heard? For anyone looking at a distressed situation, understanding these first steps shows you the legal starting line and the immediate transparency required.
All right, so the case has started. The initial info dump has happened. Who are the main players that step in to manage things? And critically, how does everyone who needs to know actually find out what's going on?
Yeah, this is where the focus shifts to actually running the case and keeping people informed. You start seeing key figures emerge, like trustees, examiners, sometimes specialized roles like ombudsmen. In Chapter 11, often the company's existing management stays in control as the debtor in possession, or DIP.
DIP.
But the rules also outline how an independent trustee or an examiner can be appointed. This might happen if there are serious questions about the management's conduct, like fraud or gross mismanagement, or sometimes just based on the sheer size and complexity of the case, especially public companies. Someone has to request it, usually the UST or a major creditor.
Can the creditors themselves try to force a change in management by electing a trustee?
Yes, that's a powerful tool creditors have in Chapter 11. The rules allow creditors to ask the U.S. trustee to convene a special meeting specifically for electing a trustee to take over from the DIP management. There are specific voting procedures for that.
Interesting. Are there any unique roles for specific types of businesses in bankruptcy?
Yes, a good example is in healthcare bankruptcies. The rules provide for the appointment of a patient care ombudsman.
What do they do?
Their job is vital. Monitor the quality of care being given to patients by the bankrupt healthcare provider. They act as eyes and ears for the court and patients. The rules detail their duties, how they report to the court, and importantly, how notice of their reports gets sent out widely to patient representatives, state licensing boards, etc., while still protecting patient privacy under IPO.
Okay, and what about creditors' committees? You always hear about those in big corporate cases.
Absolutely central, especially in Chapter 11. Usually, the U.S. trustee appoints an official committee of unsecured creditors. This committee represents the interests of all unsecured creditors as a group.
So they act as a unified voice.
That's the goal. The rules even allow the court to look at committees that might have formed before the bankruptcy filing to make sure they were put together properly and are truly representative. These committees have real power. They can investigate the debtor, hire their own lawyers and financial advisors, paid by the estate, negotiate the reorganization plan, and really influence the direction of the case.
With potentially thousands of creditors,
Right.
plus committees, trustees, the debtor. How does everyone possibly stay informed about hearings, deadlines, major proposed actions? It seems like a logistical nightmare.
That's exactly why the Rule on Notices Rule 2002 is arguably one of the most fundamental and critical rules in the whole system. It's the engine driving due process. It ensures that parties who have a stake get the information they need to protect their rights.
So who gets notice, generally?
The general requirement is broad.
Mm.
Notice usually has to go to the debtor, the trustee if there is one, all creditors listed on the schedules, and indenture trustees who represent bondholders.
And what triggers a formal notice? Are there standard timelines?
Rule 2002 lists a whole bunch of events that require specific notice periods, usually sent by mail or electronically if agreed. Many common things need at least 21 days notice. Think about the first big meeting of creditors where the debtor gets questioned under oath, or hearings on dismissing the case, or the deadline to object to property the debtor claims is exempt.
Okay, 21 days for those. What about bigger stuff?
More significant events often trigger a longer notice period, typically at least 28 days. This includes things like the hearing to approve the Chapter 11 disclosure statement, that document explaining the plan, or the actual hearing to confirm the plan itself. Also, proposals to sell substantially all of the debtor's assets outside the normal course of business usually need that longer notice.
And the notice itself has to contain specific info. It can't just say hearing on Tuesday.
Definitely not. The rules require the notice to be informative. For example, if the debtor wants to sell property, the notice needs a general description of what's being sold, the key terms of the sale, and if it's a public auction, the time and place. If someone's asking the court to approve their professional fees, the notice has to say who's asking and exactly how much money they want for fees and expenses.
So recipients can actually understand what's being proposed and decide if they need to show up or object.
Precisely. It allows for informed participation.
I noticed something in the rules about using specific addresses for notices, especially for big institutions. How does that work?
Yeah, that's a practical recognition of reality. Large entities like big banks get thousands of bankruptcy notices. The rules allow them to work with notice providers, specialized services often used by courts or major parties for mass mailings to designate a specific agreed-upon address where all their notices should be sent. Maybe it's a central processing unit or a third-party service.
So notice sent there counts as proper notice.
If they formally agreed to use that address with the provider, yes, notice sent there is generally considered proper service on them.
What if a big creditor later says, "We never got that notice"? Is there any way to prevent them from using that as an excuse?
The rules try to address that. A creditor generally can't complain that a notice wasn't brought to their attention unless they took a specific step beforehand. They needed to have filed a statement with the court designating the exact person or department within their organization responsible for handling bankruptcy notices and describing their internal procedures for getting notices to that specific person.
So it puts the burden on sophisticated creditors to set up a reliable internal system if they want to later claim non-receipt.
Exactly. If they haven't done that, it's harder for them to argue they were unaware. The rules also have specific provisions for noticing foreign creditors or dealing with notices in Chapter 15 cross-border cases.
Beyond these specific event notices, what are the ongoing duties of the debtor or trustee during the case? Are they just waiting for big hearings?
Oh no, definitely not. The rules impose ongoing responsibilities. The trustee, or the debtor in possession in Chapter 11, has to keep detailed financial records for the estate. They need to make regular reports to the court, and the U.S. trustee often monthly operating reports in Chapter 11 showing income, expenses, cash flow. They also have to give other required notices as things come up.
Like keeping track of assets.
Yes, for instance, in Chapter 7, the trustee has to file an inventory of all the debtor's property shortly after being appointed. It's about continuous accountability and transparency.
What if the bankrupt company owns or controls other businesses, like subsidiaries? Do they have to report on those too?
Yes, that's covered by a relatively newer rule. If a Chapter 11 debtor or trustee has a controlling or substantial interest in other entities, they generally have to file periodic reports providing financial information about those other entities as well.
Why is that? To get the full picture.
Exactly. It prevents assets or operations from being hidden away in subsidiaries. It ensures creditors and the court understand the whole economic enterprise controlled by the estate. There are exceptions if the info is already public, like for an SEC filer, or if it's genuinely impossible to get, but the default is disclosure. The rule even requires notifying the controlled entities before filing the report so they can object if needed.
This relentless focus on disclosure. It seems like a major theme. What about groups of creditors acting together, like unofficial committees or big bondholder groups? Do they have special disclosure rules too?
Yes, and what's really fascinating here is Rule 2019, which specifically targets these groups. It mandates very detailed disclosures by any entity or committee that represents more than one creditor or equity security holder in Chapter 9, municipal bankruptcy, or Chapter 11 cases.
Beyond just listing who's in the group.
Way beyond. It requires them to disclose their disclosable economic interests. And that term is defined incredibly broadly. It's not just the face amount of the bonds or claims they hold. It includes things like options, swaps, derivatives, participation agreements. Basically, any financial instrument or right whose value is affected by the claims or interests they hold.
So they're trying to uncover complex financial positions or potential hidden agendas?
Precisely. The rule requires them to reveal the identity of every member of the group, the nature and amount of all these economic interests, when and how they acquired them, and other relevant details. This really begs the question, why demand such incredibly detailed, almost intrusive disclosure from these influential groups?
Well, I guess it's to make sure these groups, who are often heavily involved in negotiating the plan and shaping the outcome, aren't secretly playing a different game. Maybe they have side bets or conflicts of interest that could harm other creditors they claim to represent.
That's exactly the concern. It's all about transparency and smoking out potential conflicts. Are they genuinely acting for the common good of their class of creditors, or is their position driven by some unique, perhaps hedged or short, financial interest? Rule 2019 aims to put that information on the table. For anyone involved, especially someone considering investing in distressed debt or equity, analyzing these 2019 disclosures is absolutely critical to understanding who the real players are and what might be motivating their actions.
Okay, shifting focus a bit. For a creditor, the most basic thing is getting paid, or at least getting their claim recognized. How does that process work under the rules? Filing a proof of claim.
Right. The main way a creditor formally tells the court, hey, I'm owed money, is by filing a proof of claim. The rules govern this, and there's usually an official port form, Form 410, that they use. It's the creditor's sworn statement detailing who owes them, how much, and why.
Who can actually sign and file that?
Yeah.
Just the creditor?
Usually, yes, the creditor or someone they authorize, like their attorney. But interestingly, the rules also have a backup. If a creditor doesn't file their claim by the deadline set by the court.
Which happens, right. Sometimes creditors miss deadlines.
It does. So if the creditor doesn't file, the rules allow the debtor or the trustee or even someone who is also liable with the debtor on that debt, like a guarantor or cosigner, to file a claim on behalf of the creditor.
Why would the debtor file a claim for a creditor?
Often because the debtor wants that debt to be dealt with in the bankruptcy, perhaps paid through a Chapter 13 plan or discharged. If the creditor doesn't file, the debt might just pass through the bankruptcy unaffected, which the debtor might not want. Filing on their behalf ensures it's included. The clerk then notifies the actual creditor that this claim was filed for them.
Does the creditor need to attach proof that the debt is real when they file their claim?
Yes, absolutely crucial. If the claim is based on any kind of written document, a contract, a loan agreement, an invoice, a court judgment, the rule says they must attach a copy of that writing.
What if it's lost?
If the original is lost or destroyed, they have to attach a statement explaining what happened. And for claims based on consumer credit agreements, there are even more specific attachment requirements, details about the last transaction date, charge-off date, the original creditor, etc. Any interested party can also request a copy of the supporting documents directly from the claimant.
What about secured creditors, like a mortgage lender? Are there special rules for them, especially about fees or costs they add after the bankruptcy filing?
Yes, particularly for claims secured by the debtor's main home. A specific rule requires these lenders to file periodic notices itemizing any fees, expenses, or charges they've incurred after the bankruptcy started that they intend to collect, things like late fees, attorney fees for the bankruptcy work, property inspection costs.
To prevent surprise charges piling up.
Exactly. They have to file these notices promptly after the charges are incurred and serve them on the debtor, the trustee, and the debtor's attorney. It promotes transparency about the ongoing cost of the secured debt during the bankruptcy.
And if the lender fails to file those notices, are there teeth in that rule?
Oh, yes. The rule states that if the secured creditor fails to provide the required information about these post-petition fees and charges, the court can step in. After giving the creditor a chance to explain, the court might prevent them from using the missing information as evidence later on. Or the court could award other relief, like making the lender pay the debtor's reasonable expenses and attorney's fees incurred because of that failure. It definitely has consequences.
Okay, so the claims process is very structured, requires proof, and has specific disclosure rules.
Well,
What if someone, the debtor, the trustee, another creditor, thinks a filed claim is wrong?
That's where objections come in. It's very common for parties to object to claims. Maybe they think the amounts is wrong, or the claim shouldn't be secured, or it's a duplicate, or it was filed after the deadline. Any party in interest can file an objection.
And you mentioned omnibus objections before. That's objecting to a bunch of claims at once.
Exactly. In big cases with thousands of claims, it would be incredibly inefficient to file a separate objection for every single issue. So, the rules allow omnibus objections, usually filed by the debtor or trustee, when there's a common legal or factual reason to object to multiple claims.
Like maybe 100 claims are all missing the required paperwork.
Perfect example. Or maybe 50 claims are duplicates of other filed claims. The rules require these omnibus objections to be structured, clearly list the claims alphabetically, state the specific grounds for objection for each claim or group. But interestingly, the rules also typically limit how many claims you can target in a single omnibus objection, often capping it at 100 claims.
A limit. Why limit it if it's supposed to be efficient? That seems counterintuitive.
It does, but this raises that important question, why the limit? The primary reason is manageability, both for the court having to rule on it and, importantly, for the creditors who receive it.
So a creditor doesn't get hit with a 500-page document objecting to 2,000 claims and have to wade through it all to find theirs.
Precisely. Capping it, say at 100, makes it feasible for a creditor to actually locate their claim on the list and understand the specific reason why it's being challenged. It balances efficiency with fairness and practicality. The rules also allow for reconsideration if a claim was previously allowed or disallowed, perhaps if new evidence comes to light.
Okay, so claims get filed, objected to, resolved. What's the end goal, especially in cases like Chapter 11, where the aim is to reorganize, not just liquidate?
The ultimate goal in Chapters 11, 12 for family farmers, fishermen, and 13 for individuals with regular income is getting a plan confirmed by the court. This plan is the roadmap for how the debtor will reorganize their finances and how creditors will be treated, paid back over time, maybe have debt terms changed, or receive equity in the reorganized company.
And the rules govern how that plan is developed and approved.
Absolutely. The rules cover filing the plan document itself, and in Chapter 9 and 11 cases, also filing a separate crucial document called the disclosure statement.
A disclosure statement. What's its purpose again?
It's essentially the information packet that goes out to creditors and equity holders before they vote on the plan. The rule requires it to contain adequate information, enough detail about the debtor's business, the plan's proposals, the risks, the potential alternatives, like what happens in a liquidation, so that a typical investor or creditor can make an informed judgment about whether to vote yes or no.
And the court has to approve this statement before the company can even ask for votes.
Correct. The court holds a hearing just on the disclosure statement. The debtor has to convince the judge that the information is adequate. This is a key protection for voters. It prevents plans from being pushed through based on misleading or incomplete information.
So you can't just sell your plan with slick marketing. You need court-approved substance.
Exactly. Once the disclosure statement is approved, then the rules dictate how it gets sent out. Typically, the approved statement, or a court-approved summary, the plan itself, or a summary, a ballot for voting, and a notice are all mailed out. The notice sets the deadline for voting, the deadline for objecting to the plan confirmation, and the date for the confirmation hearing.
Can the plan be tweaked after it's sent out for votes, maybe based on negotiations?
Yes, plans can be modified before the confirmation hearing. But there is a catch. If the modification makes the treatment for a class of creditors or interest holders worse than in the original plan they already voted to accept.
They get a do-over.
Basically, yes. The rules say if the change is adverse, those who previously accepted are generally deemed to have rejected the modified plan unless they actively accept the modification. They usually get notified and may get a chance to change their vote.
Okay, so then comes the big day, the confirmation hearing.
Right. The rules detail this process. This is where the judge decides if the plan meets all the numerous requirements of the bankruptcy code. Things like, is the plan feasible? Can the debtor actually pull off what it promises? Does it treat creditors fairly according to the priority rules? Was it proposed in good faith? Does it comply with all the legal requirements? Parties can file objections raising these issues before the hearing.
What if no one objects to the plan? Does the judge still scrutinize it?
The judge still has to find that the plan meets the legal standards. But the rules have an interesting provision. If no objection to confirmation is timely filed, the court may determine that the plan was proposed in good faith and not by any means forbidden by law, without necessarily needing to take evidence on those specific points. A lack of opposition carries significant weight.
If the judge does confirm the plan, how do creditors actually start getting paid according to its terms?
The rules cover distribution under the confirmed plan. The plan itself will designate who is responsible for making the payments, often the reorganized debtor company, or sometimes a dedicated dispersing agent or plan trustee. They then follow the plan's instructions on who gets paid, how much, and when. And once the plan is mostly carried out and the case administration is complete, the rules provide for a final decree to be entered in Chapter 11, officially closing the case.
Now, for individuals, and sometimes even for corporations getting liquidated in Chapter 7, a huge goal is the discharge, getting rid of debts. How do the rules handle that?
The discharge is a cornerstone of bankruptcy relief, the legal release from personal liability for most debts. The rules cover the process for granting or denying it. There are timing rules, for instance. The discharge usually isn't granted until at least 60 days after the first meeting of creditors, and not until the debtor completes their financial management course and files the certificate.
What if a creditor or the trustee thinks the debtor shouldn't get a discharge at all, maybe because they hid assets or lied?
That's a very serious challenge. Objecting to the debtor's entire discharge requires filing a formal lawsuit within the bankruptcy case, what we call an adversary proceeding. The rules clearly state that the party objecting to the discharge has the burden of proving their case. They have to convince the judge, based on evidence, that the debtor committed one of the specific acts listed in the code that bars a discharge, like fraudulent transfers, perjury, or failing to explain a loss of assets.
Okay, so that's fighting the whole discharge.
Yeah.
What about arguing that one specific debt shouldn't be discharged, even if the debtor gets a general discharge, like a debt incurred through fraud?
That's a related but distinct process also governed by the rules. While the general discharge wipes out many debts, the Bankruptcy Code lists several categories of debt that are non-dischargeable by law: recent taxes, domestic support, student loans usually, debts from drunk driving accidents, and debts obtained by fraud or false pretenses, among others.
And creditors have to act to protect those specific debts.
For certain types, yes, particularly those based on fraud, embezzlement, or willful and malicious injury. For those debts to survive the bankruptcy, the creditor must file their own adversary proceeding complaint, asking the court to determine that their specific debt is non-dischargeable. And there's a strict deadline to file this complaint, usually 60 days after the first date set for the meeting of creditors. The rules require the court clerk to notify all creditors of this important deadline. If the creditor misses it, they generally lose the chance to have that debt declared non-dischargeable.
Wow. So the rules carefully distinguish between challenging the overall discharge and challenging the dischargeability of a particular debt with different procedures and deadlines. It's really mapping out that fresh start.
It really is. And beyond getting to a plan or a discharge, the rules are also critical for managing the day-to-day operational aspects of the case, especially for a business trying to keep running while in bankruptcy.
Operational aspects, like what kind of practical things fall into that?
A really crucial set of rules, often grouped under Rule 4001, deals with motions about the automatic stay and key business activities. This covers requests for relief from the stay, like a secured lender wanting permission to foreclose. It covers motions asking for permission to use, sell, or lease property belonging to the estate, especially if it's outside the ordinary course of the debtor's business.
Like selling a major factory.
Exactly. Or motions to use cash collateral. That's a big one.
Cash collateral.
Yeah.
That's cash that a lender has a lien on, like incoming payments from customers.
Precisely. If a lender has a security interest in the debtor's accounts receivable, the cash collected from those receivables is cash collateral. The debtor generally can't use that cash without the lender's consent or a specific court order. And finally, Rule 4001 covers motions to obtain credit getting new loans or financing while in bankruptcy.
These all sound like absolutely fundamental things a business needs to do just to survive or fund a turnaround attempt.
They are vital. A company in Chapter 11 can't just decide to sell off its headquarters or take out a new multi-million-dollar loan on its own. The rules require formal court approval, usually obtained by filing a motion. These typically follow the procedures for contested matters, meaning they are resolved by motion, notice, and potentially a hearing, rather than requiring a full adversary proceeding lawsuit.
Can a creditor ever get the automatic stay lifted immediately, like in an emergency, without giving the debtor a heads up.
The rules allow for that possibility, called ex parte relief, but it's very rare, and the bar is extremely high. The creditor has to convince the judge, usually with sworn statements, that they will suffer immediate and irreparable harm, like property being destroyed or moved before the debtor could even possibly be heard in opposition.
A really high standard.
Extremely high, and the creditor's lawyer has to certify in writing what efforts they made to give notice or explain why notice shouldn't be required. It's a drastic remedy because it bypasses the basic right to be heard.
What about those crucial motions to use cash collateral or borrow new money? For a company bleeding cash, getting financing can be the difference between life and death.
Incredibly important, and the rules put significant controls around this. Motions asking to use cash collateral or obtain new post-petition financing, often called DIP financing, have strict content requirements. They must include a copy of the proposed financing agreement and the proposed court order.
Okay.
And significantly, if the motion plus the attached agreement is longer than 5 pages, the motion must begin with a concise summary, no more than 5 pages long, highlighting the key terms.
A mandatory executive summary. Why?
It's designed to make it easier and faster for the judge, the U.S. trustee, and all the other parties, especially creditors and committees whose interests are affected, to quickly understand the most critical and potentially controversial parts of the proposed deal. The summary has to spell out things like interest rates, maturity dates, default triggers, what collateral the new lender is getting, especially if they're getting senior to existing lenders, borrowing limits, and any other potentially troublesome provisions like releases for the lender.
So maximum transparency on the key deal points right up front.
Exactly. It facilitates efficient review and allows parties to quickly decide if they need to object. These motions always require notice and an opportunity for a hearing, although if no one objects after proper notice, the court might approve it without an actual hearing.
So these operational rules, they provide the pathway for essential business decisions, but they layer on these requirements for court oversight, transparency, and creditor input.
That's the balance they strike. They recognize the debtor needs to operate, but they protect the creditor's stake in the assets. Similar notice requirements apply to using, selling, or leasing property outside the ordinary course. There are even special rules if the debtor wants to sell personally identifiable information, like customer lists, requiring notice about whether it complies with the debtor's privacy policy and involving a consumer privacy ombudsman if one was appointed. And orders approving these sales are usually stayed for 14 days to allow time to appeal.
And making decisions about ongoing contracts like leases or supply agreements.
That's also governed by motion practice under the rules motions to assume, keep, or reject, get rid of, executory contracts and unexpired leases. These decisions are critical for reshaping the business. Orders authorizing the assignment of a contract to someone else are also typically stayed for 14 days.
What if there's property the company just doesn't want anymore? Maybe it's worthless or costs too much to maintain.
The rules allow the trustee or debtor in possession to formally abandon property of the estate if it's burdensome or of inconsequential value. They have to give notice, and parties can object. Alternatively, a party in interest, like a secured creditor stuck with collateral they can't foreclose on due to the stay, can file a motion asking the court to compel the trustee to abandon it.
Okay, so we've covered starting the case, managing it, claims, plans, discharge operations. What about actual lawsuits within the bankruptcy? Like if the debtor needs to sue someone to recover money owed to the company, or if they want to claw back payments made right before filing.
Yes. What's really interesting here is the whole system of adversary proceedings, often just called APs. These are, for all intents and purposes, formal lawsuits that happen under the umbrella of the main bankruptcy case.
Lawsuits within the bankruptcy.
Exactly. The rules, specifically Rule 7001, lists 10 specific types of relief that must be sought by filing an adversary proceeding, not just a motion. And Part 7th of the bankruptcy rules basically imports and adapts most of the standard federal rules of civil procedure to govern these APs.
So if you need one of these specific types of relief, you have to file a formal complaint, serve it properly, and follow lawsuit procedures.
Correct. It's much more involved than motion practice. What kinds of things require an AP? Actions to recover money or property. Classic examples are lawsuits to recover preferential payments made to creditors shortly before bankruptcy or to undo fraudulent transfers of assets. Also, proceedings to determine the validity, priority, or extent of a lien on property, with some exceptions.
Like arguing whether a mortgage is valid.
Precisely. Or actions to get court approval to sell property owned jointly by the debtor and someone else. Complaints seeking to revoke a debtor's discharge or revoke a plan confirmation order, again, with exceptions. Those actions we discussed earlier to determine the dischargeability of a specific debt, like for fraud. Actions seeking an injunction, or proceedings to subordinate one creditor's claim to another's.
So these are often the really high-stakes disputes within the case.
Yeah.
And because they follow civil procedure rules, that means things like formal discovery.
Absolutely. APs involve formal service of the summons and complaint, following specific rules for serving different types of defendants, individuals, corporations, the U.S. government, etc. And yes, you get the full range of discovery tools. Depositions, interrogatories, written questions, requests for production of documents and electronically stored information, requests for admission, inspections of property. It's full-blown litigation just adjudicated by the bankruptcy judge.
That definitely adds another layer of legal complexity and cost to the process. Now, with all these decisions being made, approving plans, ruling on motions, deciding APs, what happens if a party strongly disagrees with the bankruptcy judge's ruling?
That brings us to appeals. The rules provide the framework for appealing decisions made by the bankruptcy court. Typically, appeals go first to the federal district court for that geographic region. In some parts of the country, the judicial circuits have also set up specialized bankruptcy appellate panels, or BAPs, made up of bankruptcy judges, as an alternative first level of appeal.
And how do you start an appeal?
The fundamental step is filing a notice of appeal with the clerk of the bankruptcy court, the court that made the decision you're appealing. And you have to do it within the time limit set by the rules.
How much time do you usually get? It sounds like timing is critical everywhere in bankruptcy.
It is, and the appeal deadline is quite short. Generally, you only have 14 days after the judgment or order you're appealing is entered on the docket.
Only 14 days, that's fast.
Very fast. And crucially, the rules list several specific types of orders where that 14-day deadline is rigid. The court cannot extend the time to appeal them, even if you have a good excuse for missing it.
Which orders fall into that strict, non-extendable category? And again, why those specific ones?
This is another place where you have to ask, why such a strict, unforgiving timeline for these particular orders? The list includes many of the critical operational and case-ending orders we've been discussing. Orders granting relief from the automatic stay, orders authorizing the use, sale, or lease of property, or the use of cash collateral, orders authorizing the debtor to obtain credit, DIP financing orders, orders approving the assumption or assignment of contracts or leases, orders approving a disclosure statement, and orders confirming a plan.
Wow, so basically all the key decisions that allow the business to function, restructure, and exit bankruptcy.
Exactly. If we connect this back, the rationale is the paramount need for finality on these crucial issues so the case can actually move forward. Imagine the chaos if a confirmed plan or a major asset sale could be held up indefinitely by late appeals. These orders often involve third parties relying on them, like DIP lenders or asset buyers, and time-sensitive actions. Allowing appeals to linger would destroy value and paralyze the restructuring process. So the rules prioritize certainty on these core matters, demanding immediate action if you want to challenge them.
So for those critical orders, you snooze, you lose, basically.
Yeah.
What about appealing other types of orders, maybe ones that decide an issue mid-case but aren't the final judgment?
Those are called interlocutory orders. Appealing them usually isn't automatic. It's not an appeal as of right. Generally, you have to ask the district court or BAP for permission or leave to appeal. You have to convince the appellate court that an immediate appeal is warranted. It's a higher bar. There's also a mechanism for direct appeals from the bankruptcy court straight to the Circuit Court of Appeals in certain important cases, bypassing the district court BAP, but that requires certification.
And if you do appeal, can you ask the court to pause the effect of the order while the appeal is happening?
Yes, you can file a motion for a stay pending appeal. This asks the court to temporarily halt the enforcement or effect of the order being appealed. You usually have to file this motion first with the bankruptcy judge who issued the order.
And if they say no?
Then you can typically take the request for a stay up to the appellate court, district court, or BAP. Very often, if a court grants a stay pending appeal, especially if it involves money or property, it will require the appealing party to post a bond or provide some other security.
To protect the other side in case the appeal fails.
Exactly. To cover potential damages caused by the delay if the original order is ultimately upheld.
Okay, so the rules really do provide a comprehensive legal map from the very start through managing the case, handling disputes, confirming a plan, and even challenging decisions afterward.
It's an incredibly detailed structure, and surrounding all these specific processes are general procedural rules that apply throughout. Things like where exactly you file papers, usually with the court clerk, the absolute requirement to serve copies on the U.S. trustee. Rules even cover what happens if you accidentally file something in the wrong place, like mailing it to the judge instead of the clerk. The court might still accept it if no one is prejudiced.
And electronic filing is standard now.
Yes, electronic filing through the court's CMECF system is the norm, and the rules address that, confirming electronic signatures are binding.
And the court keeps track of everything meticulously.
Oh, yes. The rules mandate the clerk keep detailed dockets for every case, logging every single document filed and order entered. They maintain claims registers when needed. They keep copies of judgments. There's even a specific register of mailing addresses designated by government agencies to ensure they get proper notice.
Timing is clearly king. Are there standard ways to calculate deadlines?
Yes. Rule 906 provides detailed rules for computing time periods, how to count days, exclude weekends and holidays, add extra time if service was by mail. It also covers asking for extensions of time, but again, emphasizing those critical deadlines that generally can't be extended. And most motions require at least 7 days' notice before the hearing, unless another rule or court order says otherwise.
What about making sure lawyers and parties act properly? Are there rules about filing frivolous things or acting in bad faith?
Absolutely. Bankruptcy Rule 911 is the equivalent of Rule 11 in regular civil litigation. It governs representations made to the court. When an attorney or an unrepresented party signs or files any document, they are certifying that they've made a reasonable inquiry and believe the filing isn't for an improper purpose, like harassment or delay, the legal arguments are non-frivolous, and the factual claims have evidentiary support.
And if they violate that, sanctions.
Yes, the court can impose sanctions for violating Rule 9011. The goal is deterrence. Sanctions can range from non-monetary directives to ordering payment of a penalty to the court, or if another party brought the violation to the court's attention via a specific safe harbor motion procedure, the court might order the violator to pay the other party's reasonable attorney's fees and costs caused by the violation. There are some limits, though, for instance, on monetary sanctions against a represented client for purely legal arguments made by their lawyer.
One last area with all this sensitive financial data flying around, what about privacy?
Very important point. Rule 9037 mandates the redaction of sensitive personal information from court filings. Parties are required to only include, for example, the last 4 digits of Social Security or taxpayer ID numbers, the year of birth, only minor children's initials, and only the last 4 digits of financial account numbers.
To protect individuals from identity theft in public records.
Exactly. It's a critical safeguard given the public nature of most court filings. So, you see, if we pull all this together, these rules covering procedure creation, case initiation, information flow, claim handling, plan confirmation, operations, appeals, general conduct, privacy, they create this highly structured, complex, but ultimately predictable environment for addressing financial distress in the U.S. The goal is order, transparency, and a measure of fairness among all the competing interests. Understanding this legal playing field is absolutely step one for anyone dealing with distress situations.
Okay, let's step back from that incredibly dense legal code for a moment and look at the flip side, the intense business reality that's happening inside that legal framework. Our Forbes article tackles the challenge of actually leading a distressed company, and it paints a picture of it being one of the absolute toughest jobs out there.
It really is. The Forbes piece makes no bones about it. Leading a company on the brink is profoundly difficult. You're not just managing through a tough economy. You're dealing with severe cash shortages, intense pressure from creditors breathing down your neck, terrified employees, potentially angry customers, and the constant shadow of failure.
So according to that Forbes framework, when a leader realizes the company's in serious trouble, what's the absolute first thing they need to do?
The turnaround roadmap in the article starts with digging deep to identify the real root causes of the distress. It's easy to see the symptoms, right? Running out of cash, sales tanking, losses piling up. But you have to push past that to figure out why.
Not just papering over the cracks.
Exactly. Is the core business model broken? Did competitors just leapfrog us with innovation? Are our internal operations incredibly inefficient and costly? Did we just take on way too much debt in the past? You have to diagnose the underlying disease, not just treat the fever.
How do you even do that accurately when you're in the middle of a 5-alarm fire and everyone's stressed?
It takes a really rigorous, sometimes painful diagnostic effort. It means brutally honest analysis of the financials, not just surface numbers, but digging into product line profitability, customer acquisition costs, cash burn rates. It means actively soliciting and listening to customer feedback. Why are they leaving? What aren't we delivering? It means scrutinizing operations. Where's the waste, the bottlenecks? Sometimes it takes bringing in outside experts for a fresh, unbiased look. The key is getting past assumptions and politics to the hard truths.
Okay, once you've hopefully pinpointed those root causes, the next step is building the strategy to fix them. The article uses the word robust.
Yes, and this is where the business reality really meets the pressure cooker environment. A robust turnaround strategy isn't just a hopeful PowerPoint deck. It has to be grounded in reality. It needs clear, measurable, achievable milestones. Specific actions, specific timelines, specific accountability, and the Forbes article explicitly warns leaders against the siren song of over-optimism at this stage.
Over-optimism?
Yeah.
That seems weird. Don't leaders need to be optimistic to inspire people in a crisis? Why is that dangerous?
It's dangerous because unrealistic projections can be fatal. If you build your turnaround plan based on, hockey stick sales growth that just isn't plausible, or assume you can slash costs way faster than is humanly possible.
It sets you up for failure.
Exactly. When those overly optimistic targets inevitably get missed, it completely shatters credibility. Employees lose faith, customers get nervous, and crucially, creditors and potential investors or lenders run for the hills. It makes the leadership look clueless or dishonest. A realistic plan, even if it involves painful truths, builds trust and provides a believable path forward that people might actually support, including in a formal restructuring context.
Makes sense. So what kind of operational areas does the Forbes article highlight for focus once you have that realistic strategy?
A huge focus is on driving profitable revenue and aggressively managing costs. This might involve finding new revenue streams, but often in a crisis, it's about focusing limited resources on what actually makes money. The article stresses the need to identify profitable customers, profitable products, profitable regions, and double down there.
And the flip side.
The flip side is being willing to make incredibly tough calls to exit unprofitable businesses, discontinue money-losing products, or shed non-core assets, even if they have historical significance or emotional attachment. It requires ruthless prioritization.
That sounds like it involves really difficult decisions, layoffs, cutting back. Leading people through that kind of turmoil and uncertainty must be the hardest part.
Arguably, yes, which raises that critical question. How do you lead people effectively when their jobs are on the line, the company's future is uncertain, and fear is rampant? The Forbes article hammers home that strong leadership combined with clear, constant, and honest communication is non-negotiable.
So the leader has to be visible and upfront.
Absolutely. They need to rally the team, be transparent about the challenges, explain the reasons behind the tough decisions, even the painful ones like layoffs, and articulate the turnaround plan clearly and repeatedly. They need to provide regular updates, not just to employees, but also to key external stakeholders like major creditors, suppliers, and important customers.
So that transparency we talked about in the legal rules is just as vital, maybe even more so, from a business leadership perspective.
Totally. It builds confidence, or at least minimizes panic and disruption. It shows you're facing reality and have a plan. That credibility is essential for maintaining support, keeping key employees from jumping ship, and reassuring customers that you'll still be around to serve them. It can literally make or break the turnaround effort.
So summing up the Forbes perspective on leading through distress, what are the absolute must-haves?
It really boils down to a combination of things. Sharp, strategic thinking to accurately diagnose the core problems and chart that realistic path forward. Really tough, decisive decision-making, often involving painful cuts and laser focus, and critically inspirational yet credible leadership grounded in constant, transparent communication to maintain morale and stakeholder confidence. And the article rightly points out there's no single magic formula. Every distress situation is unique. Flexibility, resilience, and that unwavering focus on getting back to a profitable, sustainable business model are key.
Okay, so we have these two parallel worlds. On one hand, this incredibly detailed legal framework from the bankruptcy rules, the formal structure, the procedures, the court oversight. On the other hand, this intense business challenge described by Forbes, diagnosing problems, building strategy, making cuts, leading people through crisis. How do these actually connect? How does the legal structure impact that business fight for survival?
This is really the crux of it. where the two streams merge. The legal rules aren't just some abstract background noise. They actively shape, constrain, and sometimes enable the business strategies that the leader is trying to implement. The legal system provides the arena, defines the rules of engagement, but also imposes limitations and creates specific opportunities that directly influence the turnaround effort.
Can you give some concrete examples of how that legal framework directly affects the business strategy?
Sure. Let's start with the automatic stay again. That's purely a legal construct, triggered by filing the petition. From a business perspective, it's hugely valuable. It provides that critical breathing room the Forbes article implies is needed for diagnosis and strategy development. It stops the bleeding from lawsuits and collection actions.
So the law creates space for the strategy.
Exactly. But the rules also allow creditors, especially secured creditors, to file motions seeking relief from the stay if their collateral isn't protected or the debtor has no equity. So the business leader can't just relax. They're under pressure from the legal system to demonstrate progress and show how their turnaround strategy protects creditor interests. Otherwise, that breathing room might vanish.
What about getting money? The rules around using cash collateral or getting new DIP financing seem like a direct legal impact on daily operations.
Absolutely prime example. For most distressed businesses, access to cash is oxygen. The business strategy might identify the urgent need for cash to make payroll, buy inventory, fund critical repairs, but whether they can use the cash they collect, if it's subject to a lender's lien, or how quickly and on what terms they can get a new emergency loan, DIP financing, is entirely dictated by the bankruptcy rules.
Requiring court approval, lender consent, those detailed motions.
Right. The leader's brilliant business plan might be dead on arrival if they can't successfully navigate the legal requirements under Rule 4001 to get the court order allowing them to use cash or borrow money. The legal process directly enables or blocks the funding needed for the business strategy.
And looking towards the end game, the claims process and confirming a plan, that seems like the ultimate intersection.
It absolutely is. The business strategy aims to design a viable, profitable future company. But that future company needs a new balance sheet. A sustainable capital structure. How much debt can it handle? Who owns the equity? The legal claims process determines who the creditors are and establishes the amounts they are legally owed.
Setting the stage for the negotiation.
Exactly. And then the legal rules for plan, confirmation, feasibility, fairness, like the absolute priority rule, good faith, best interests of creditors, test provide the framework and the legal standards that any negotiated deal must meet to be approved by the court. The business turnaround strategy has to be translated into a formal legal plan document that can survive creditor voting and judicial scrutiny under those confirmation rules. The best business idea in the world won't succeed if it can't be implemented through a confirmable Chapter 11 plan.
So the legal structure isn't just a hurdle, it's also the mechanism for implementing the turnaround, providing tools like the stay, but also setting the standards the turnaround has to meet.
Perfectly put. It's both an enabler and a constraint. And for anyone interested in this world, maybe as an investor, understanding this dynamic is everything. The legal rules create potential opportunities, buying claims, lending money, acquiring assets, investing in the reorganized equity. But evaluating whether those are good opportunities requires analyzing both the legal process governing them and the underlying business's realistic prospects for success, using the kind of strategic thinking outlined in Forbes. It's a high-stakes game played simultaneously on legal and business chessboards.
It really sounds like you need to be fluent in both languages, the language of the law and the language of business strategy, to navigate this successfully.
Without a doubt, operating effectively in corporate distress demands competence, or at least strong advice, in both realms.
Okay, so wrapping up this deep dive into the complex world of U.S. bankruptcy and corporate turnarounds.
We've journeyed through the intricate legal landscape laid out by the federal rules of bankruptcy procedure. We saw how these rules create a formal, step-by-step framework for everything initiating the case, managing operations under court supervision, handling creditor claims, developing and confirming reorganization plans, granting the discharge, and even appealing decisions. It's a system designed to bring order and process to financial chaos.
And alongside that legal structure, we explore the intense business challenges highlighted in the Forbes article, the sheer difficulty of leading a distressed company, the critical need to diagnose root causes accurately, craft a realistic turnaround strategy, make painful operational decisions, and communicate with unwavering transparency and strength to keep stakeholders on board during profound uncertainty.
And the core takeaway, really, is that navigating corporate distress successfully in the U.S. requires mastering both of these dimensions. You have to understand and operate effectively within that incredibly detailed legal structure, while simultaneously executing a challenging, high-pressure business turnaround strategy. Success truly hinges on understanding and managing that constant interplay between the legal rules and the business realities.
It's this continuous negotiation between what the law requires and what the business needs to survive and recover.
Absolutely. A constant balancing act.
So here's a final thought to leave you with, building on all of this. Consider the inherent tension between the structure and the chaos. You have these bankruptcy rules designed for predictability, fairness, and order. Then you have the business reality of a crisis, which is often messy, unpredictable, and fast-moving. Does that rigid legal framework primarily help rescue efforts by providing necessary tools and structure? Or does the sheer complexity, the cost, the potential for delay inherent in navigating these detailed rules sometimes become an obstacle in itself, adding layers of difficulty that can actually hinder or even prevent a potentially viable turnaround? Something to ponder as you see companies navigating these turbulent waters and think about how value is ultimately preserved or lost in the process.